We will go ahead and get started with our Religious Liberties Practice Group panel. My name is Michael Moreland. I am a law professor at Villanova University outside of Philadelphia, and I am the chair of the Federalist Society's Religious Liberties Practice Group. And it's an honor to welcome you here to our panel on church autonomy in the modern era. If you're interested in the work of our practice group, we have a number of webinars and podcasts available at the Federalist Society website, including 2 in the last year on this topic, and several on recent Supreme Court cases such as Mahmoud versus Taylor, Catholic Charities versus Wisconsin, which one of our panelists argued, and the Oklahoma charter school litigation. But now I will, so if you're interested in that, please do look at those. And if you are interested in the work of our practice group and joining us, please let me or Marco Lloyd or other members of Federal Society staff know. And I do want to thank Nate Kaczmarek and Marco Lloyd and the other members of the staff for their hard work in putting together this whole program, but the whole conference, but especially this panel. So with that, I'll turn it over to our moderator. Judge Matthew Kaczmarek serves as United States District Judge for the Northern District of Texas. He previously served in the private, government, and nonprofit sectors as an associate in the Dallas office of Baker Botts, LLP, as an assistant United States attorney for the Northern District of Texas, and as deputy general counsel to the First Liberty Institute. Judge Kaczmarek is an honors graduate of the University of Texas Law School, where he was a member of the Federal Society and served as executive editor of the Texas Review of Law and Politics. As an AUSA, he worked on FISA national security cases and earned the 2013 Attorney General's Award for Excellence in Furthering the Interests of U.S. National Security. As counsel to First Liberty Institute, he focused on religious liberty appeals at the circuit level and Supreme Court and legislation protecting conscience rights in healthcare and other sectors. He was nominated to be a federal district judge by President Trump and was confirmed in 2019. And with that, I'll turn it over to Judge Kaczmarek.
So let me introduce this rockstar panel that we've assembled here. This really is like a constellation of superstars in this space. So to my immediate left, Alex Luchenitzer, who serves as Associate Vice President, Associate Legal Director for Americans United for Separation of Church and State, sometimes abbreviated AU. He received his BA from Harvard University, his JD from Stanford, and you'll recognize his work in several high-profile cases, including AU versus Prison Fellowship Ministries, Doe versus Elmbrook School District, Williamson versus Brevard County, and represented the litigants there through the circuit level, and many other cases. We could be here all day if I go through all of the case names that these panelists have worked on. Most recently, he published a 2019 article on a hollow history test, why Establishment Clause cases should not be decided through comparisons with historical practices. And before that, an article published in the Social Sciences Journal, Religious Freedom as a Tool to Oppress, the Explosion in Religion-Based Attacks on Civil Rights in Litigation. So, to his left, we have Eric Rossbach, a fellow Texan who works with the Becket Fund for Religious Liberty, where he serves as vice president and senior counsel. He's also the executive director of the Religious Liberty Clinic at Pepperdine Law School. He earned his BA from Haverford College and his JD from Harvard Law School. They didn't give him an opportunity to clerk in the Northern District of Texas, so he clerked at the Southern District. That's a joke. For Judge Lee Rosenthal. So he and I both come from the same law firm, Baker Botts, but he's done way more Supreme Court cases through his work at Becket, including work on Hosanna Tabor, Hobby Lobby, Holt v. Hobbs, Zubik versus Burwell, Fulton versus Philadelphia, Mahmoud versus Taylor, and argued 2 of the cases that set the stage for this panel, Our Lady of Guadalupe versus Morrissey, and Catholic Charities versus Wisconsin Labor, both of which he argued at the Supreme Court. So next we have Mary Ann Case, who serves as the Arnold Schur Professor of Law at the University of Chicago. She earned her BA from Yale, her JD from Harvard Law School, then also studied at the Ludwig Maximilians University in Germany. And before becoming a professor and focusing on scholastics exclusively, she litigated at Paul Weiss in New York City, Cravath, and Baker and McKenzie. Her more recent articles include a 2014 piece, The Ladies, Forget About Them, A Feminist Perspective on the Limits of Originalism. And then more recently, in 2021, she published an article, Who Conquers with This Sign? The Significance of the Secularization of the Bladensburg Cross. And you can read that article at the Roger Williams University Law Review 2021 publication. And finally, but certainly not lastly, Stephanie Barclay, who is now serving here in Washington, D.C. as a Georgetown Law School professor of law. She's also the co-director of the Georgetown Center on the Constitution. She received her BS and JD at BYU University and a PhD in law at University of Oxford. Her clerkships include the Ninth Circuit with Judge Randy Smith, the Supreme Court with Justice Gorsuch, and she did her litigation at Covington and Burling and spent a stint at Beckett Fund along with Eric Rosbach, and also as director of the Notre Dame Law School Religious Liberty Initiative. Her most recent articles include Replacing Smith, which was published at the Yale Law Journal Forum, and then this year, she will have a forthcoming article at the University of Pennsylvania entitled The Untold Story of the Proto-Smith Era, Justice O'Connor's Papers and the Court's Free Exercise Revolution. So look forward to that. This panel is subdivided into three parts. As we envisioned it, we'll have two opposing views paired with each other with color commentary, and we'll go through each topic in that sort of order. So, and we have reserved time for questions, so I know that there's microphones at opposing sides of the room, and you can make your way there as we approach the finish line. So, topic one, the current state of the church autonomy doctrine. As hinted in this event's CLE description, the church autonomy doctrine, which is recognized in, of course, Hosanna Tabor and other cases, has appeared in several recent opinions. Notably, the court addressed the doctrine in Our Lady of Guadalupe and also in Catholic Charities versus Wisconsin. And to open up our discussion on that, I'm going to turn first to Mr. Luchenitzer. With this question, I'll invite response from Mr. Rosbach. How has the court used, or in some cases not used, this doctrine, using more recent Supreme Court cases as a lens?
Thank you, Judge Kaczmarek. The court's decisions have properly treated church autonomy as a limited principle that protects religious institutions from direct governmental interference in how they govern themselves and what they believe. The use of the term church autonomy to describe a doctrine of religious freedom law was actually adopted by the Supreme Court fairly recently. The first case to use that term was the court's 2020 decision in Our Lady of Guadalupe. There, the court defined the doctrine as protecting religious institutions' independence in matters of faith and doctrine and in closely linked matters of internal government. In explaining how the doctrine has been applied, the court pointed to two kinds of past cases, both of which have a limited scope. First, the court pointed to cases holding that courts and other governmental bodies cannot decide questions of religious doctrine and override the decisions of church tribunals about church leadership or control of church property. But the court's cases have also held that it is entirely proper for judges to resolve church property disputes by applying neutral principles of law instead of wading into questions of religious doctrine. The second class of cases, as explained in the Our Lady of Guadalupe case, are ministerial exception cases, and that That case explained that the ministerial exception doctrine is essentially a subset of the church autonomy doctrine. The ministerial exception doctrine prohibits employment discrimination laws from being applied to employment decisions by religious organizations concerning their clergy and other employees who perform vital religious duties. But the ministerial exception does not apply to employees whose duties are not religious. This past June, in its decision in Catholic Charities, the Supreme Court rejected an attempt to drastically expand the scope of the church autonomy doctrine. In that lawsuit, 5 Catholic-affiliated social service agencies were seeking a statutory exemption from a Wisconsin unemployment tax law. The statute provides exemptions for houses of worship and, as interpreted by the state Supreme Court, for religiously affiliated organizations that do not proselytize or discriminate based on religion in the provision of services. The Catholic agencies were incorporated separately from their affiliated Catholic dioceses and did not proselytize or discriminate when providing services. The lead argument that the Catholic agencies made in the briefing before the U.S. Supreme Court was that Wisconsin's distinctions violated the church autonomy doctrine because those distinctions gave the agencies incentives to merge with their Catholic diocese and to proselytize or discriminate in providing services, all of which would have been contrary to their religious beliefs. In a concurring opinion, Justice Thomas took a position somewhat different than what the Catholic agencies argued, and wrote that because the Catholic diocese considered the Catholic social service agencies part of the diocese as a religious matter, the church autonomy doctrine required courts to defer to that view and ignore the fact that the Catholic diocese voluntarily decided that its social service agencies should be incorporated as separate entities. The Supreme Court's majority ignored the Catholic agencies and Justice Thomas's church autonomy arguments and ruled in favor of the Catholic agencies on the ground that Wisconsin had created a denominational preference. The court's refusal to accept these broad church autonomy arguments was consistent with its past precedents and wise. The Supreme Court has never suggested that government action violates the church autonomy doctrine merely because it provides a religious entity some incentive to change how it is structured or to change its behavior or beliefs, or because the religious entity holds beliefs that are inconsistent with legal realities. And accepting these kinds of arguments would effectively allow any religious organization to ignore any law that it does not like. For example, a religious group whose beliefs require it to incorporate heavy drug use into its activities would have a right to ignore drug laws because those laws give the group incentive to change its beliefs. For the same reason, a religious group whose beliefs called for plural marriage would have a right to ignore laws prohibiting polygamy. And a religious entity that believes its employees are under the control of a higher power, not under the control of the religious entity itself, could avoid liability for an employee's sexual abuse of children. I'm sure Eric might have some interesting responses, and I'll look forward to hearing from Eric whether I accurately describe what Eric argued for the petitions of Catholic Charities.
Well, and Mr. Rosbach, we can't have a better respondent because you actually argued these cases. So what is your response?
Sure. So first, thank you to the Federalist Society and to Judge Kaczmarek for this panel, which I think is on a very topical issue. And I will get to the response part, but first I need to do something, which is I live in Silicon Valley, and there we have what you call tech evangelists. So these are people who walk around on a stage wearing a turtleneck and a head mic, and try to tell you why you should buy the latest version of the iPhone and cash in your one that cost a couple $1,000 the year before. And I'm here today to be a church autonomy evangelist. Though I'm not wearing a turtleneck. Church autonomy is one of the single biggest developments in the law of religious liberty in the last couple of decades. The Supreme Court's express recognition and application of the concept in the Our Lady of Guadalupe case is going to echo through the jurisprudence for years and decades to come. So what is church autonomy? It's the idea, born out of both religion clauses, so the Establishment Clause and the Free Exercise Clause of the First Amendment, that protects religious bodies against government interference in matters of faith and doctrine and in closely linked matters of internal government. The concept is an umbrella one, so it has a series of sub-doctrines, which Alex was just alluding to, in different areas of the law. One of them is the ministerial exception, of course, which involves employment. But aside from employment, this issue, church autonomy, comes up in property cases, church or religious body membership cases, internal governance cases involving these institutions, labor relations, whether a church body's employees can unionize, donations. There's been a suite of those cases around the country recently. Church communications to the faithful and whether those can be interfered with or not by civil lawsuits, and many others. Since Our Lady of Guadalupe took the concept that had been existing in a lot of different prior cases, going back at least to 1872, though I would argue even 1813 in People against Phillips, but certainly back to 1872 in Watson against Jones, there was this class of cases that didn't really fit neatly into either the Free Exercise Clause or the Establishment Clause. And what the court said in Our Lady of Guadalupe is that was this concept called church autonomy. It was borrowing a term from the scholarship of Doug Laycock, who's recently retired from the University of Virginia Law School. And now, since the time that Our Lady of Guadalupe was decided 5 years ago, there's been a host of different jurists that have weighed in on it. Judge Bumate, who spoke earlier today, and Judge Bress both wrote in the Huntsman en banc case at the Ninth Circuit, that Paul Clement argued, actually. Judge Park on the Second Circuit, Judge Brennan on the Seventh Circuit, and several others that I'm leaving out in the interest of time, so please don't get mad at me. Judge Oldham recently wrote an excellent opinion in the McRaney case, which I think we're going to be discussing later, that really laid out a lot of the current issues in concerning church autonomy. And just 2 days ago, Judge Rao on the D.C. Circuit wrote a lengthy dissental in O'Connell against United States Conference of Catholic Bishops that involves whether a disgruntled parishioner can bring a class action in United States court against the Catholic Church about how the Pope spends the annual Peter Pence's collection. And I can talk more about that later. That case will be the subject of a forthcoming cert petition in case anyone's interested in doing an amicus brief. The key factor that I would say just in the recent developments is that by putting a name on the concept, Our Lady of Guadalupe gave the doctrine, sort of triggered a wave of court thinking about it and jurisprudence about it. And I think that's going to keep going for, a few decades. Now, to get to the response part, I think Alex would love to sort of put the genie back into the bottle, but I think it's out and it's not going to go back in. I did get a very interesting question from Justice Kagan at the oral argument in Catholic Charities Bureau earlier this year, where she said, "Well, you're talking about more about this third question in your brief, not the first one." And I think I didn't say it quite this way, but it's sort of like, I love all my arguments just like I love all my children, But I think I don't think it, saying that the Supreme Court had three completely separate ways to decide a case that was so outrageous. In this case, it was Wisconsin saying that if Catholic Charities proselytized or only served Catholics, then it would get better treatment than what it actually does, which is it doesn't proselytize and it does serve non-Catholics. I think that's why we got a 9-0 opinion written by Justice Sotomayor. So the fact that there were two other separate ways that violated the Constitution, to my mind, doesn't really tell you anything at all about what the court is ultimately thinking. And the reality is we may end up getting a second bite at the apple in the Catholic Charities case, because Wisconsin is now trying to say that on remand that we're not going to have, instead of giving Catholic Charities the tax exemption that it had fought for 8 years, they're going to try to get rid of the tax exemption for all the religious organizations instead. And so maybe we'll be back at the Supreme Court soon about that issue. I don't know if have I hit my time, or should I keep
Close,
going?
you're close. So why don't we pivot to McRaney? So this was referenced during both of your comments, and importantly, because it involves my boss on the Fifth Circuit, Judge Oldham. So in that McRaney case, Judge Oldham characterized the church autonomy doctrine as something like jurisdictional. So this obviously raises questions for practitioners and professors. What should we think of that argument there when it comes to collateral orders, things like immunity doctrines? Let's jump into the McRaney reference there and this idea that something like the doctrine can be jurisdictional and what that means for those that practice in this space. And keeping with form, I'll start to my left and then allow a response.
So, am I going first, or is he going first?
We'll keep in the order.
Okay, got it.
Yeah.
Okay.
Mr. Luchenitzer, you can respond first.
Okay, thank you, Your Honor. Okay, sure. So, the Supreme Court has already addressed this issue of is the church autonomy doctrine jurisdictional? In the Hosanna Tabor case, the court ruled that the ministerial exception is an affirmative defense and not a jurisdictional bar. And since the ministerial exception is part of the church autonomy doctrine, this must mean that the church autonomy doctrine also is not jurisdictional. And so, consistently with the Supreme Court's ruling, the 2nd, 7th, 10th, and DC circuits have all rejected arguments that decisions concerning the church autonomy doctrine are immediately appealable before final judgment. And that's, the biggest practical significance of the question of is it jurisdictional or not goes to whether decisions on a motion to dismiss or summary judgment. When a motion to dismiss or summary judgment on the church autonomy doctrine is denied to the religious organization, can the religious organization then bring an immediate appeal? And the only contrary Fifth Circuit, the only contrary decision in this issue is Judge Oldham's recent opinion for the Fifth Circuit in McRaney. And the discussion there on the issue is really entirely dictum, because McRaney was an appeal from a final judgment. In any event, the other four circuits are legally correct that church autonomy decisions should not be immediately appealable. The Supreme Court has made clear that appeals from non-final decisions should be permitted only in rare circumstances, and has repeatedly cautioned lower courts not to attempt to expand those circumstances. In the relevant test, which considers the collateral order doctrine, which is the primary way that appeals could be taken in these kinds of cases, asks about three things. It asks whether the decisions are conclusive, separate from the merits, and effectively unreviewable after final judgment. And except in situations involving improperly intrusive discovery or taking of live testimony, which can be addressed separately through writs of mandamus, any harms threatened against houses of worship by an incorrect decision on church autonomy would not become final and irreparable until enforcement of a judgment, and so could be addressed through an appeal of a final judgment together with a stay of the judgment. And in my view, any argument that the fact that a trial court merely makes decisions on religious issues improperly, if it's not a final decision, it's tantamount to just hearing about conduct you disagree with, and the Supreme Court has kind of narrowed situations where that is a basis for harm, or at least for legally cognizable harm. So anyway, treating the church autonomy doctrine as a jurisdictional immunity from trial that allows immediate interlocutory appeals would also conflict with the textualist approach of recent Supreme Court jurisprudence. The Supreme Court has cautioned that the class of decisions where an immediate appeal should be allowed under the collateral order doctrine should only be expanded where there is an explicit statutory or constitutional guarantee that trial will not occur. An example is the Constitution's speech and debate clause, which provides that members of Congress shall not be questioned in any other place. Nothing in the First Amendment, however, is an explicit guarantee that trial will not occur. And if non-final church autonomy decisions are held to be jurisdictional and immediately appealable, why should any other important First Amendment rights be treated differently? Would all interlocutory decisions concerning the Free Exercise Clause and the Establishment Clause become immediately appealable? What about interlocutory decisions concerning the Free Speech Clause and other clauses of the First Amendment? What about interlocutory decisions concerning other components of the Bill of Rights? I mean, all these kinds of rights are very, very important, and some sort of temporary abridgment of or deprivation of these rights could also easily inflict great harm on the agencies or people asserting those rights. So to conclude, allowing piecemeal appeals on church autonomy doctrine grounds would also be bad public policy. It would make it extremely difficult and expensive for plaintiffs to litigate cases against religious organizations, because it could enable the organizations to take multiple interlocutory appeals in a single case. For example, at the motion to dismiss stage, and then again at the summary judgment stage. The result would effectively be denial of access to justice for most people who are harmed by religious organizations.
And because Judge Oldham is my boss, and I'm governed by what the Fifth Circuit says about such things, and because we're both Texans, can you tell me how to think about McRaney and this jurisdictional concept?
Sure. So Judge Oldham's opinion for the Fifth Circuit is a really fascinating discussion of jurisdiction, or that's one part of the opinion. There's actually a lot of other parts to it, but the jurisdictional part is particularly fascinating. And jurisdiction is famously a word of many meanings, too many meanings. Judge Oldham kind of runs with that a little bit and says that church autonomy doctrine is in a way both jurisdictional and non-jurisdictional. It's jurisdictional in a broad conceptual sense. So, for example, in the sense that civil courts don't have the power to decide, religious questions about whether, Jesus is the Messiah or something like that. But it's also non-jurisdictional in the narrower Rule 12b1 sense. That is, that it's not something that would be the subject of a subject matter jurisdiction challenge, a motion to dismiss, that would then get, result in the case getting dismissed without prejudice. I found his opinion to be very convincing, though I'm not sure I agree with every particular. But in the end, I don't think it matters for the real question that Alex was talking about, which is, do you get to appeal right away, or do you have to go through discovery? Because that's really what this is all about, is do these religious nonprofit organizations have to go through years of civil discovery before at the end getting to the point where the court says, well, actually you were immune to that, and you actually you have church autonomy, so actually we shouldn't have had all that discovery in the first place. Our view that we've now litigated in a number of cases is that the church autonomy question ought to be resolved right at the beginning of the case and not at the end. Jurisdictional or not, it's a threshold issue. You shouldn't, the price of, making this kind of argument should not be having to go through years of depositions and document discovery and the high costs, which, of course, again, most religious groups are nonprofits, and don't necessarily have the wherewithal to respond to all of those things. The O'Connell case that I mentioned earlier really epitomizes this issue because, the question really becomes, does the Catholic Church in this country have to go through a class action lawsuit with possibly millions of potential members of the class, essentially every Catholic parishioner in the country, and then go through the attendant years of discovery about very sensitive religious matters in order to reach that church autonomy question? Or is that an issue that ought to get decided right at the very outset of the litigation? You can imagine a class action plaintiff's lawyer deposing the papal nuncio. What did Pope Francis know and when did he know it? Pope Francis specifically is part of the complaint in this case, and some things that he said are part of the case. They can't sue him because he has sovereign immunity and he's also passed away. But this is not something that anyone should really want the federal courts dealing with. And if you believe in separation of church and state, which I think Alex does, then you really shouldn't want this kind of entanglement between the two things. So that's my contribution there.
Okay, so let me break there. And if you can tell, we have a pairing of practitioners and then a pairing of professors. Any follow-up color commentary from the professoriate?
Okay, first of all, I don't think Stephanie is appropriately limited to the professoriate, since unlike me, she litigates.
Yes, that's true. This is true. So that was.
I am, when it comes to these matters, purely the professoriate. And I come at the end for the big think. But to situate myself, I mean, this is how Judge Kaczmarek has divided things. To situate myself, Eric described himself as an evangelist. The evangelium is the good news. I do not think church autonomy is the good news. I am the opposite of an evangelist for it. I think of myself at a lot of these gatherings under the title of Hasatan, the adversary. So I am here to tell you church autonomy is a bad idea. It is not only a bad idea, it is an extraordinarily recent idea with virtually no American roots. It has, interestingly, and I'll talk about this in the Big Think section, ancient roots. The aptly named Becket Fund is dealing with a period in time when church autonomy was real, but that was in part because there was a thing called the church. Now, there's a bunch of academics who have organized themselves under the heading freedom of the church, but they've had difficulty explaining what the church is now after the Reformation. As to the jurisdictional issue, I would hope that we could take Chief Justice Roberts at his word in the unanimous Hosanna Tabor opinion, which is until recently the only opinion that has anything close to church autonomy, although not using the word. He says that the ministerial exception, which our prior speakers are encompassing under church autonomy, is not jurisdictional. That, I think, is quite correct, unless you're Thomas Becket.
Well, actually, we did the Hosanna Tabor case, and our position in the litigation was that it is not jurisdictional. So that was our position in Hosanna Tabor.
I mean literally Thomas Becket, not the Becket.
Oh, okay. Sorry.
Okay, so with that, I'll turn to professor, practitioner, clinician, and all-around genius, Stephanie Barclay. Any color commentary on topic one?
My mom would be very proud of that introduction.
Yeah.
Okay, thank you. I guess I just want to add to this a little bit the discussion about where is the church autonomy doctrine coming from and what are its origins, and also what's the textual argument for it. If we're reading the First Amendment, which talks about the free exercise of religion, but also the Establishment Clause, Eric alluded to this, but the church autonomy doctrine, as I see it, really lives at the intersection of free exercise and church autonomy. And so in that way, this is some of the strongest protection we have under the First Amendment. I would commend to you some recent scholarship by Lyle Weinberger, including a current work in progress he has right now, where he's engaging with Sally at Penn and arguing that there are a lot of historical origins for church autonomy. He has some earlier scholarship and some forthcoming scholarship about that. So we didn't necessarily call it church autonomy, but we make up fancy labels for modern doctrine all the time that still have deep historical roots in our common law jurisprudence. And I think that's true of church autonomy doctrines. So the thing that's interesting about church autonomy doctrines is that they're often providing a categorical protection in the way that strict scrutiny does not. So when it applies, then in some contexts, the government doesn't get to justify and override whatever is going on in that context. So in an employment hiring situation, the government wouldn't be able to say that it has a compelling reason and narrowly tailored to override a religious organization. Church autonomy extends, as Eric pointed out, more broadly than just the ministerial exception, though that's an important one. And we're seeing lower courts like the Fourth Circuit and the Ninth Circuit interpret the ministerial exception even very broadly to apply to drama teachers that don't really do anything with religion. So I think it's interesting to see ways in which, as that doctrine has expanded, it's also, there's still pressure on some of these other doctrines to be fleshed out. And I'm just going to talk a little bit about some of the ways in which I think some of these other doctrines are important to keep an eye on. So Markle is another case. We mentioned McRaney, but Markle coming out of the Ninth Circuit is another one that talks about ways in which there are jurisdictional protections under church autonomy. We also have church autonomy protections, one that Justice Gorsuch wrote about in a separate writing about concerns of government weighing in, courts weighing in on religious questions, internal church communications receiving separate protection, other employment decisions beyond non-ministers. Those are all things that are on the horizon where the court really, I think, is thinking about how to theorize the doctrine in these areas. And we've had separate writings by Justice Alito, one that was joined by Thomas, Barrett, and Kavanaugh, talking about how this is a pressing issue in the employment context outside of the ministerial exception that the court is likely going to have to tackle soon and will likely have to theorize. One difference between ways in which the doctrine will probably operate in the employment context beyond the ministerial exception is that there, a religious employer would still have to give a religious reason for why they were firing someone, whereas under the ministerial exception, there's just really no questions asked. If the religious employer says, we just don't want to have a relationship with this person anymore, that's the end of the road and that's the end of the story. Alex spoke earlier about ways in which this could be harmful for vulnerable groups, but from interactions with and talking to a lot of different religious organizations, this is actually one of the most powerful tools that religious organizations have to get rid of leaders that they have found have engaged in things like sex offenses and have done things that have been harmful for youth and vulnerable people in their congregations. And it's been a powerful tool for them, and one that if we took away might actually have the opposite consequences that Alex is worried about.
Okay, so in the interest of time, I think if you're tracking our notes, I think we'll go ahead and skip over the next question, further defining the ministerial exception. And that is because Professor Case has stated that she really wants to camp out on the big think portion and reserve some time for that. So let's advance forward to topic 2, religious employers, and specifically how this relates to employer litigation. So as a setup for this concept, I want to cite the Herx case. So that was a 7th Circuit case from 2014. There, the appellate court declined to hear a Title VII claim under the collateral order doctrine. There, a Catholic school teacher had engaged in IVF and her contract was not renewed. The court did not apply the First Amendment church autonomy doctrine and did not allow immediate appeal under Title VII. And as the church autonomy doctrine expands, and we think about McRaney and then also the contours of the ministerial exception, how could this development in the context of something like Title VII religious employer litigation swallow the doctrine or expand it, depending on which direction you want to go? So I'll turn first to Mr. Lucien Eitzer, and then followed by Eric Rossbach, and then, as always, color commentary from the rest of the panel.
Thank you, Judge Kaczmarek. Yeah, so I think Stephanie's already touched on some of this. So litigants have repeatedly attempted to use the church autonomy doctrine to expand exemptions from employment laws for religious organizations. So and they've made a range of arguments. The most narrow arguments, which are, I think, pretty squarely within the scope of existing doctrine, are, that the case requires the court to resolve issues of religious doctrine. kind of an intermediate approach, which I think is beyond the scope of existing doctrine, is an attempt to expand it, is that the doctrine bars the claim when the employment decision is religion-based. And that would really create a very broad exemption, because it would be very easy for a religious organization to assert that its employment decision was religion-based, and pretty hard for the plaintiff to disprove that. And the broadest approach, which I think litigants don't generally expressly say that this is what they're doing, but at least I felt that this is what the petitioners were doing in the Catholic Charities case, is presentation of arguments that would expand the doctrine so broadly that the doctrine would effectively cover all employees of all religious organizations. And as I've indicated before, these broad efforts to expand the church autonomy doctrine are improper. They're inconsistent with the Supreme Court case law, and they're especially improper because they would render the ministerial exception superfluous. Because if all religious organizations are exempt, then why do you need this body of ministerial exception law, which holds that the exception only applies to employees who perform vital religious duties? And the court has also explained that the ministerial exception doctrine is part of the church autonomy doctrine, so it doesn't make any sense to expand the church autonomy doctrine so much that it would render the ministerial exception completely unnecessary. So for the most part, the efforts by litigants to expand the church autonomy doctrine in the employment sphere have not been very successful. In recent years, at least at the federal appellate level, courts have generally refused to adjudicate church autonomy arguments in employment cases, and have generally relied on the ministerial exception to dismiss cases. So, for example, just earlier this year in a case called McMahon versus World Vision, the Ninth Circuit relied on the ministerial exception, not the church autonomy doctrine, to rule in favor of a religious organization, and the court reaffirmed that the church autonomy doctrine does not exempt religious employers from employment discrimination laws, except to the extent required by the ministerial exception. And last year, in a case called Billard versus Charlotte Catholic High School, the Fourth Circuit relied on the ministerial exception to bar an employee's claim, even though against a religious school, even though the school tried to waive the ministerial exception in the district court and asserted before the Court of Appeals that the church autonomy doctrine gives it greater protection than the ministerial exception does. And the McCraney case we've talked about is an exception. The court relied on both the church autonomy doctrine and the ministerial exception doctrine to rule that claims that one Baptist organization caused a related Baptist organization to fire a minister were barred, although that wasn't a completely straightforward employment case, because the lawsuit wasn't against the organization that actually terminated the minister. So anyway, the more the church autonomy doctrine is expanded in the employment context, the less often courts will end up reaching statutory questions of Title VII interpretation. So it's certainly the case that you, as Your Honor asked, if the doctrine is expanded, it could end up swallowing Title VII jurisprudence. And that's especially true if courts are convinced, as Eric has advocated, to treat the doctrine as jurisdictional, which would mean that courts would be required to address whether the doctrine applies before considering any statutory questions. Another thing I want to point out that it's the church autonomy doctrine is just one of several ways in which attorneys for religious organizations have been attempting to expand religious exemptions from employment discrimination laws. So religious institutions have also argued, as Stephanie mentioned, that the ministerial exception itself should be interpreted for much more broadly, and that who qualifies as a minister should be interpreted more broadly. Religious organizations' attorneys have also worked to import the First Amendment's freedom of association doctrine into the employment context to allow them to hire and fire non-ministerial employees based on religious reasons. And I mean, in my view, those efforts are contrary to a Supreme Court decision called Hushan versus King and Spalding, which rejected an attempt to use freedom of association principles in the employment discrimination context. And finally, litigants for or attorneys for religious organizations have argued that the exception in Title VII that allows religious employers to hire employees of the same religion also allows the employers to discriminate against employees who did not conform their conduct to the employer's religious tenets. So if successful, any of these efforts, not just the church autonomy doctrine, but any of these efforts to expand religious exemptions from employment discrimination laws could drastically change the face of employment suits involving religious organizations.
And Mr. Rosbach, I know when we were both in the nonprofit sector, this was one of the cases that we looked at in the first instance. You're not, of course, limited to Herx, but what's your response to the idea that an overexpansion of the doctrine could counterintuitively swallow some of the protections under Title VII?
Sure. So I don't think that the church autonomy doctrine will swallow all of the other doctrines, including the statutory protections. The best overview of this area, I think it's very a textured area. So there's like just really, there's differences between the different kinds of protections that you can invoke as a religious employer. But the best overview of this area of the law with respect to religious hiring is my colleague Luke Goodrich's law review article, Religious Hiring Beyond the Ministerial Exception, which is forthcoming in the Notre Dame Law Review, but you can read it now on SSRN. And there he offers a comprehensive taxonomy of religious hiring protections that exist in addition to the ministerial exception. He describes 6 categories. I'll just say them very briefly. 3 are statutory. Title VII's religious exemption, which Alex mentioned. Title VII's bona fide occupational qualification exception. And the Religious Freedom Restoration Act, which there's an active circuit split about the applicability of. And the 3 of those are constitutional. So one is the church autonomy doctrine beyond the ministerial exception. Of course, the Supreme Court has defined the ministerial exception as a subset of the broader church autonomy doctrine. So it can get a little confusing because I would say every ministerial exception case is a church autonomy case, but we're sort of talking, I think when Alex was talking about church autonomy just now, he was talking about non-ministerial exception church autonomy cases. The second one is freedom of expressive association. So that would be the thing that comes up in cases like Hurley or Boy Scouts against Dale. And then finally, the free exercise clause directly. So for example, under the Smith-Lukumi standard. I think that first of all, constitutional avoidance, the doctrine of constitutional avoidance alone will mean that some of the statutory questions get addressed in the first instance. Judge Easterbrook had a concurring opinion in a recent Seventh Circuit case where he, agreed with the application of constitutional ministerial exception defense, but said, we could have just decided this under Title VII. And so I think that that's going to happen in some cases. But we also shouldn't really be that surprised that different religious protections overlap. It happens all the time. Justice Gorsuch talked about this recently, talking about how you shouldn't be surprised when you have a religious speech claim that they can have overlapping free exercise clause and free speech clause claims. That's just sort of natural in this space. And so I don't think they usually consume each other so much as they're overlapping things, and it depends on the specific facts of the specific cases about which defenses a religious employer might raise and in what posture. So I don't see it as a conflict so much as they're complementary.
Okay, so before we pivot to the topic 3, the TED Talk of Religious Liberty, Big Think.
Matthew, can we say something about that?
Yes,
Okay.
I do want to give your color commentary here.
So you've heard from one of the articles that Judge Kaczmarek mentioned I'd written that I'm interested in women's rights. And I therefore would be remiss if I did not say, in the context of the ministerial exception, that it has been really bad for women employed by churches. This was true in the early days when the ministerial exception was being developed as lower court doctrine, as a workaround what the judges saw as a potential gap in Title VII. The cases involved famously a female professor of theology at a Catholic university. It is also the case that a disproportionate number of the ministerial exception cases involve gay people, including gay men, organists, and other not ordained professionals in the service of churches. If you look at the Supreme Court ministerial exception cases, Hosanna Tabor and Our Lady of Guadalupe, you'll note that while Parrish, the losing plaintiff in Hosanna Tabor, was a called teacher. That is to say, she was distinguished from teachers denominated as lay because she had more religious training and had gotten an official stamp of approval for that. She was not, in the conventional theological sense, a minister. The Missouri Synod Lutheran Church absolutely does not ordain women to the ministry. The reason there exists the phenomenon of called teachers, legal historians and historians of religion have traced to the government of the United States, which in the mid-20th century provided benefits such as housing allowances and other tax advantages to people who could be called ministers. So there was an incentive to call this woman, who had really no authority in the church, a minister for the purposes of the state, not for the purpose or for secular purposes, not for the purposes of her religious mission. If you listen to the oral argument in Hosanna Tabor, one of the things that is a running theme is whatever else we do, we have to make very, very sure that the Catholic Church isn't forced to ordain women. Okay. I think this is another problem with Hosanna Tabor. I don't know that time is going to permit me to get into it, even in a big think section, but there's a difference between ordination and employment. And one of the interesting things about Hosanna Tabor is that her ordination, her call, was not revoked. All she did was lose a job. And she never wanted reinstatement. She just wanted to be financially compensated. And this, I think, gets to something we've forgotten about the history of religious accommodation. It's only very recently that it has been thought to be necessary that it be costless. Quakers had to provide substitutes or money if they wanted to be excused from fighting. Okay, going on to Our Lady of Guadalupe, that doubles down on the problem of the injured parties in an expansion of the ministerial exception being women without authority in the church. These are basically grade school teachers in Catholic school who teach recitation of prayers, Our Father, Hail Mary, Glory be to the Father, accompany children to Mass. They have no authority in the church. If the ministerial exception is designed to create a space for the shaping of the doctrine of the church, this is not something these women do. And it's not something these women are authorized to do. No one even claims that they did it. It's also, I think, worthy of note that in none of these cases, the one we're asked to focus on here, it might potentially be an exception, the teacher who engaged in vitro fertilization. All of the named plaintiffs in the Supreme Court ministerial exception cases did nothing religiously untoward, and no one claimed that they did. They were sick. One had cancer. The other was asking for an Americans with Disabilities Act accommodation. The third was old. So I'll come back to, let me say this now, it'll jump ahead. one of the fascinating things is how Protestant an opinion Hosanna Tabor is, because it says what's important about the church is faith and mission and doctrine and speech. It's written by a bunch of Catholics, and they distinguish the clear predecessor case, Smith, by saying, oh, this is about doctrine, and that was just about outward physical signs. Now, the Catholics in the audience and the Native American peyote users in the audience may jump in and say, those outward physical signs are what we call sacraments. They are just as important as any word that is spoken or formulation of that word. I'll finally say about the ministerial exception that it's one of those, in a sense, tragic missed opportunities. It was clear that although, as our earlier speakers have mentioned, Title VII provided a variety of specific accommodations for religions to fulfill their mission, not fully constrained by the anti-discrimination requirements of Title VII, somehow this ministerial exception, which people like Justice Breyer at oral argument tried very hard to fit into existing exceptions, hadn't, in the eyes of the lower courts, been fully accommodated. If we were in an ordinary functioning government, what would have happened is that the court would have said, this is not accommodated by Title VII. It doesn't need to be constitutionalized, but Congress, you need to make this, to incorporate this exception. And I have no reason to think Congress would not have wanted to do that. So raising this to the constitutional level, I think, is a sad example of missed opportunity and has led us down this road toward infinite expansion of constitutional claims in this domain.
And Professor Barclay.
Thank you. I just want to hone in for a minute on this debate about discrimination and whether church autonomy is going to allow for more discrimination. I mean, that allegation is made about religious liberty generally a lot of the time. But another way to describe discrimination is an organization's desire to hire and select people based on its mission. It doesn't sound so terrible. And so I want to talk about how this came up in a progressive context recently. An acting government official in DC wrote a letter to Georgetown Law School saying, if you don't stop engaging in your DEI practices and some of your teaching and your curriculum, we're not going to hire your students. We think that's discrimination, the way in which you're doing your DEI practices around there. And I do think that there were some First Amendment concerns about conditioning benefits on what we were saying at Georgetown and what we were teaching. But it was interesting, Georgetown's response, and note that this is being called discrimination, what you are doing, the way that you are hiring people and the way you're running your law school. Georgetown's response was, this is part of our religious mission. This is how we cultivate our community. In fact, they were essentially making a church autonomy argument in a letter that the dean responded with for why they should be able to be protected to build their community that way. Wouldn't it be fun if Georgetown Law School embraced its religious identity more so it actually could claim religious protections like that? We're not there yet, folks. But anyway, the point is, if you disagree with how a group decides to want to run its practices, that's one thing. But that's different than saying don't be part of that group. But that's different than saying we shouldn't let groups, especially religious groups, hire people and create communities of like-minded people. And I think that principle should be and has been long in our country a really important one for how we allow private associations to form. The last thing I'll say is that the Supreme Court has suggested in cases like Catholic Bishop and Amos that if employment civil rights laws aren't interpreted broadly enough to provide protection so that religious groups can hire like-minded people who are committed to the mission and choose not to hire people who are not, then there are constitutional problems. And now under the label of church autonomy, which they weren't using that label then, that would fill in the gap. So that's been a principle that's around for a long time. And so what I think we will see is as states continue to have less protective employment exemptions, that is an area where church autonomy will have to step in more. So I think we're less likely to see it under Title VII, which has been interpreted pretty broadly. But, states like Colorado, which is the gift that keeps on giving for First Amendment jurisprudence, and now Wisconsin wants in on the action, and Seattle's competing too. We're going to see more of those sorts of situations where we have to rely on constitutional protections where statutory ones are lacking.
Yeah, depending on which side of the panel you're on, Colorado's the gift that keeps on giving or the gift that keeps on taking. So let's turn now to the promised big think or big picture segment. So here I'm going to focus primarily on our professoriate and begin with this opening question to Professor Case. How does the church autonomy doctrine fit within the history of the Supreme Court's religious liberty decisions, and specifically, is it something new or an adaptation of an idea that originates in the founding?
Okay, so Judge Kaczmarek is doing this because when we were doing the planning session, he wanted to start down in the trenches, and I said, I had very little to contribute to that, and it was my habit to start with the big ideas before heading down into the trenches, and I would try and see if that process could be reversed. Let me start by name dropping, and the name I'm going to drop is my friend Frank Easterbrook. The day before Hosanna Tabor was going to be argued in the Supreme Court, I was at lunch with Frank, and we both had exactly the same view of the, issue spotting, if you will, framework for Hosanna Tabor. We both said this is overdetermined to be a loser for the religious institution. Why? Because you have the specific case of Tony Alamo, much less respectable a religious organization than the Missouri Synod Lutherans, but they had lost a case asking to have an exemption from taxes, from employment taxes, granted the bulk of their participants who self-defined as ministers, even though, in contrast to Hosanna Tabor, the relevant people were on the same side as the church. They were not fighting the church. The court disposed of this fairly quickly and said, no, doesn't matter if you are ministers from a religious perspective. This is the way the law will treat you, and we're not going to change that. The other thing that stood in the way was, of course, Smith. Now, this was the Smith of 10 years ago, not the Smith of today, that has been whittled back and twisted around and turned into Doug Laycock's early vision of most favored nation. But that Smith said, as a neutral and generally applicable law. Employment discrimination laws are neutral and generally applicable laws. They do make accommodation for religion, but that's generally thought to be a good thing, not a thing that's going to further cause them to unravel. So we all said, this is going to be a very difficult case for Hosanna Tabor to win. And then, lo and behold, even though Tony Alamo was cited correctly by lots of the briefs, it didn't get mentioned. It again didn't get mentioned in Our Lady of Guadalupe. It remains good law, but no one is dealing with it. And I've already told you what was said about Smith. Preaching on the one hand, outward physical signs on the other, and that's the difference. Already said that I think of Hosanna Tabor as a Protestant decision. One of the big things we people in the teaching religion, whether in a law school or elsewhere, are accustomed to do is to say there is no one secularism. There are Protestant secularisms, there are Catholic secularisms. Query whether there can be an Islamic secularism given how pervasive Islam is in all of life. But this is a commitment by a bunch of Catholics to a fairly Protestant vision of separation of church and state, of the relationship between church and state. Now, there is a long history. I mean, it's not, I don't think, so much, although Chief Justice Roberts did heroic work trying to make it such, a history measured from the time since the framing. I don't know whether you noticed that the history of the religion clauses. So many of the Supreme Court cases that discuss the religion clauses give a capsule history. Chief Justice Roberts told a completely unique, unprecedented capsule history of the religion clauses. And where did he start? Where no one else had started, with a text that figured in only 2 footnotes in amicus briefs and rarely, if ever, in an opinion. He started with Magna Carta. The English church shall be free. Now, and then he went on to say, of course it wasn't. He immediately said this is a promise made but not kept. But again, if you are going to look for the origins of the church autonomy doctrine, I wasn't kidding when I said not the Becket Fund, but Becket. These are things that are very much debated in the pre-Reformation Middle Ages, and I continue to think are very difficult to translate, and there's no good reason to translate them over to the world after the Reformation, even though if we were going to take the beginning of Chief Justice Roberts' history as good, it doesn't say the English church is free. It says the English church shall be free. This suggests that this is not jurisdictional. This is not tu there are, if you're familiar with the phrase so often quoted by freedom of the church types. It suggests that freedom is something that is within the king's power to grant or withhold, and he chose to grant it. In any event, I don't see traces in the case law. We've already talked about how late the words came in. And this whole church autonomy doctrine is a product of the Roberts Court. It is not a revival, it is an innovation.
And Professor Barclay.
But again, like that's ignoring what's going on in Amos and in the Catholic Church versus NLRB cases, which predate the Roberts Courts, where there's this huge constitutional avoidance issue operating in the background for how we're interpreting statutes like Title VII. How the court seems to suggest if we didn't interpret Title VII broadly, there would be a constitutional issue. What constitutional issue is it? They don't call it church autonomy there, but that's what's going on. So I guess and since 1872, the Supreme Court has said that courts shouldn't be able to second guess religious organizations in matters of their doctrine and their membership and their organization, their polity, their hiring. So I just think it's less new than you suggest. I think it depends on what you're looking for in the case law. One other thing that I want to flag, this idea that the church autonomy doctrine as it currently exists is like a very Protestant doctrine. I guess I'm not sure quite what you mean by that. But let me just say really quick.
Not the church autonomy doctrine, the ministerial exception.
Okay, the ministerial exception doctrine. Yeah, I'm still not sure what you mean by that. But in the amicus brief filed by Usma Uden in Our Lady of Guadalupe, she argued about ways in which if the ministerial exception doctrine was interpreted as the court did to focus more on the functional prong of the test, is this person functionally operating in ways that convey the faith to future generations, that was a really important protection for minority religious groups like Muslim groups. And so I think that the doctrine as it exists is one that is very capacious and important by focusing on that functional element so that it can capture and protect religious minorities, not just your run-of-the-mill Protestants in America.
Can I say 2 things? First of all, Tony Alamo is a minority religion. That case is still good law. Those ministers were not accommodated. And then let me also kick up the controversy one more notch and say the way this ties into the Roberts Court is in the Roberts Court's turn to corporatism. Hosanna Tabor is the first case that brings together the free exercise and establishment clause and says that it's religious institutions, not just individuals, including in their formation of institutions, that is intended to be protected. I have frequently called Hosanna Tabor citizens of the City of God United, and I would put into the mix the whole line of cases about exception under the Affordable Care Act to the contraception mandate, both by for-profit corporations and by religious institutions, each of them, like church autonomy doctrine is heading toward, claiming the right to shape the world around them exactly as they wish and then be accommodated religiously for doing that. So, for example, the owners of Hobby Lobby, the Greens, said, well, we couldn't just pay the fine and have someone else cover the insurance because we feel called to pay for the insurance. So I use this as a title in another article of mine. There is a lower court judge who, dealing with these cases, described them as creating a patchwork array of theocratic fiefdoms. And I think of all of this movement being, again, a movement back to something like feudalism, both for the Catholic Church and for the Green family.
Well, you did take it up a notch. So I'll give Professor Barclay the last response and then also maybe a preview of your forthcoming article published at Pennsylvania Law Review, the Proto-Smith era.
Actually, can we have Eric weigh on this? I'd be interested in your thoughts about this, Eric. I didn't know that we were breaking up the panel, the boys section and the girls section. So I'd be interested in you.
That's not how we did it.
It's the professorate and the litigators. Sorry, what am I responding to, though? Just what Marianne just said?
Yeah, yes.
Well, I mean,
Like, are we creating theocratic fiefdoms by the
Yeah. So I disagree with maybe 90 everything that Marianne said except and thee. For example, Hosanna Tabor, it was absolutely part of the case. We handled Hosanna Tabor. One of our main claims was that she violated Lutheran teaching by doing what she did. That's why she got fired. She'd
already been fired.
But my point is that if you read the case, you will see that was the grounds that we offered. So it was not true that no one said anything about their performance religiously. That was absolutely the core claim that we were making. Both of the principals who fired the two teachers in Our Lady of Guadalupe, the two different cases, were both female. They were the ones who were exercising authority to fire those things, and they wanted to bring maybe some male judges in the federal judiciary to overrule their rulings as Catholic school principals. The idea that these, suddenly brand new is just, frankly, kind of silly. Like Watson against Jones it was an institutional case. It's about whether you can go into some Presbyterian churches that were feuding, a Presbyterian church that was splitting up in Kentucky, and say that they, are not able to, you can just interfere with that in the court system. And they say, no, you can't do that. Or Kedrov and Kreshik in the 1950s, Russian Orthodox Church. So the idea that suddenly, institutional just came about with the Roberts Court is frankly just silly. So I completely disagree with that. I don't think that there's any way you can plausibly make that claim. And of course, ideally, our principles do go back to the Magna Carta. Arguably, we have these freedoms that we've been trying to develop over time, and we're not just trying to make up things on the fly and then, since circa 1960. So I don't see anything wrong with citing Magna Carta. I think we probably should do it a little bit more.
Okay, so we are now, I think Professor Case may have been correct. We might have started with topic 3 and started with some fireworks. So we are now at the 5 o'clock mark. I do want to give, if anybody has a pressing question, you don't get this constellation or array of talent always. I'll maybe allow just 1 or 2 questions, but they got to be quick because they have to prepare this room for the rest of the conference.
Thank you. I had a question about the originalist perspective on the establishment issue, because until the late 19th century, some states before incorporation, they did have state churches. And wouldn't that state church be the only church that has full autonomy, considered maybe even as an equal branch of government? And now, since incorporation, we have a situation where no church has church autonomy with the abolition of the established churches. But the same majority, which, for example, might be 90% one religion, by creating secular rules, is effectively still only allowing the majority view or the majority concept of what a religion is to have autonomy, whereas the minority religions don't get that same protection because they don't create the same sort of facially neutral Smith type rules and regulations.
Okay, quick response. Who wants it? Raise your hand.
Okay, I'll just
Okay.
go very quickly. I mean, it's crystal clear that church autonomy and the ministerial exception in particular applies to all different religions equally. So I just don't think there's any question about that. The Markle case that Professor Barclay was mentioning is, against the Orthodox Union denomination. There's actually quite a few religious minority ministerial exception cases out there. So I don't think that there's, and as Professor Barclay also mentioned, like religious minority groups in these ministerial exception cases, both in the Supreme Court, but also in the lower courts, show up with the amicus brief saying we really need this protection. So they argue that it's actually even more necessary for them because they're less understood. So they actually need the protection more.
One last question, and then I have to give instructions for the rest of the evening.
Okay, I don't understand why jurisdiction is so important to the interlocutory appeal argument. The qualified immunity is not jurisdictional, but people still get interlocutory appeal. The key question is whether the trial or the civil proceeding violates the right that you're trying to protect. And there's plenty of language, I think it's in Kedroff, that says that the trial in a civil proceeding is exactly what violates the church's right to be able to handle its own internal affairs. So why is jurisdiction so important in the first place anyhow?
That's that was what I was trying to say earlier, probably not clearly enough, which is I don't think it really matters because either way, it should be a threshold issue because of precisely the harms that you were identifying. So, and Professor Michael McConnell has written some briefs that just say that it's a non-jurisdictional immunity is what he says.
I'll let Marianne go, then I have some thoughts on this.
I just wanted to put in a plug for something Stephanie mentioned in passing. Sally Barringer-Gordon has been writing for a long time a book about the early history of establishment and regulation of churches in the States. And it's now finally listed as forthcoming. I recommend it to people who are interested in the first question.
And Lyle's responding to that article with one called How Churches Made American Corporations Private. So they're fun to read together. Just really quick on the jurisdictional point, and Eric touched on this, but to flesh it out a little bit more, what Judge Oldham was saying, I think correctly, is that the way in which we mean jurisdiction, this word of many meanings, is it's a limitation on power. It's a constitutional structural protection against this type of process, which itself can be the punishment. And so therefore, if we're trying to avoid that as punishment, you should be able to get immediate appellate review to ensure if you're able to be protected from that consequence before it happens. But what he was rejecting is the idea that it's just 12b1 jurisdiction, because then that just means federal courts might reject their ability to rule on those grounds, and then they would just go sue in state courts. And so there would be less protection for religious organizations if we were deciding jurisdiction in that narrower sense.
Okay, so we're at the conclusion of our panel. I do want to recommend another book. If you're new to this subject matter, you haven't practiced here or served as a professor on faculty, there's a really good summary. It has a lot of charts at the end of the book. It's kind of an anthology of a lot of these issues and cases. It's by John Whitty, Joel Nichols, and Professor Rick Garnett at Notre Dame Law School. It's Religion and the American Constitutional Experiment. So it's a really good summary of a lot of this history. If you're new to this area of law, you might use it as a roadmap. So let me go ahead and pitch Professor Garnett's book. It's one that I would assign to my own law clerks if they need a primer on this. So, announcements about the rest of your evening. So, first, if you are pursuing CLE credit, and by the way, we front-loaded this panel because we need to qualify this event for CLE. That's why we did the trench work on the cases and all that. So, if you are pursuing CLE, please use the QR code on your program, and then that should sync for CLE credit. Also, because we need to close down this room for tonight's dinner, any conversations, any follow-up questions. If you're heckling this Rockstar panel, do your heckling outside. So move all conversations to the terrace or lobby level foyers. We can do the work there and then reconvene for dinner tonight. We are adjourned, and the court stands adjourned for the rest of the day.